examine the scope of fundamental right to life and personal liberty under the Indian Constitution. Ans. Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. Safety of life and liberty of person are the two most essential things in an ordered society. The Constitution assures them not only to Indian citizens but to all persons in India. It has not been left to the whim of the executive to rob a person of his personal liberty and put him in detention. As person may be put in custody, if the law warrants, and when he is so put, it should be in conformity with the procedure established by law. All the safeguards that the law prescribes to protect the liberty of person from being jeopardized should be available to a person before he is put in detention. Personal liberty. The word personal liberty under Article 21 imports wide interpretation. In A.K. Gopalan v. State of Madras, AIR 1960 SC 27, personal liberty was held to mean liberty of the physical body, example, freedom from arrest and detention from false imprisonment or wrongful confinement. It was said that the expression personal liberty was antithesis of physical restraint and preventive detention. But this restrictive meaning has not been accepted in the subsequent case Kharak Singh v. State of UP, AIR 1963 SC 1295. It was held that the expression life was not limited to bodily restraint or confinement to person only but something more than mere animal existence. In this case, the petitioner, Kharak Singh, was charged in a dacoity case but was released as there was no evidence against him. The police opened a history sheet against him, and he was kept in police surveillance which included secret picketing of his house by the police, domiciliary visits at nights, and unification of his movement and activities. The Supreme Court held that the domiciliary visits by the police were an invasion on the petitioner's personal liberty. By the term, life as used here, means something more than mere existence. The inhibition against its deprivation extends to all those limits and faculties by which life is enjoyed. The court held that the unauthorized intrusion into a person's home and the disturbance caused to him is the violation of the personal liberty of an individual. Hence, the police regulation authorizing domiciliary visits was plainly violative of Article 21 as there was no law on which it could be justified, and it must be struck down as unconstitutional. In Satwanath Singh v. Ast. Passport Officer, New Delhi, AIR 1967 SC 1836, the Supreme Court further extended the scope of this article and held that right to travel abroad was part of a person's personal liberty within the meaning of Article 21 of the Constitution. In this case, the petitioner, who was a citizen of India, had to travel frequently for business purposes. The government ordered him to surrender the passport, but the petitioner challenged it on the ground that the right to travel abroad and return to India was part of his personal liberty. The Supreme Court accepted the contention of the petitioner and held that the right to travel abroad was part of a person's personal liberty within the meaning of Article 21, and therefore no person can be deprived of his right to travel abroad except according to procedure established by law. In fact, there was no law on which the government could justify its action. Procedure established by law. The word law in Article 21 refers to law made by the state and not to positive law or law in the abstract sense, embodying the principle of natural justice, and procedure established by law means procedure established by law made by the state, that is to say, by the Union Parliament or the legislature of the state. The Supreme Court had held in Maneka Gandhi v. Union of India, AIR 1978 SC 597, wherein the petitioner's passport was impounded, that the government was not justified in withholding the reasons for impounding the passport from the petitioner. Delivering majority judgment, Justice Bhagwati asked, is the presentation of some sort of procedure enough, or must the procedure comply with any particular requirement? He then held the procedure contemplated in Article 21 could not be unfair or unreasonable. And this principle of reasonableness, which was an essential element of equality or non-arbitrariness, pervaded Article 14 like a brooding omnipresence, and the procedure contemplated in Article 21 must answer the test of reasonableness in order to be in conformity with Article 14. Hence, any procedure which permitted impairment of individual's right to go abroad without giving him a reasonable opportunity to be heard could not but be condemned as unfair and unjust. The order withholding reasons for impounding the passport was therefore not only in breach of statutory provisions of Passport Act, but also in violation of the rule of natural justice embodied in the Maxim Audi Alteram Partem. Although there are no positive words in the statute, Passport Act, requiring that the party shall be heard, yet the justice of the common law shall supply this omission of the legislature. The power conferred on the Passport Authority to impound the passport under Section 10(3)(c) of the Act was a quasi-judicial power. The rules of natural justice would therefore be applicable in the exercise of this power. Fairness in action, therefore, demands that an opportunity to be heard should be given to the person affected. Thus, the court gave a new dimension to Article 21 in the Maneka Gandhi case. It held that the right to live is not merely confined to physical existence, but it includes within its ambit the right to live with human dignity. Elaborating the same view, the court in Francis Corelli v. Union Territory of Delhi, AIR 1978 SC 597 said that the right to live is not restricted to mere animal existence. It means something more than just physical survival. The right to live is not confined to the protection of any faculty or limb through which life is enjoyed or the soul communicates with the outside world, but it also includes the right to live with human dignity and all that goes along with it, namely, the bare necessities of life such as adequate nutrition, clothing and shelter, and facilities for reading, writing and expressing ourselves in diverse forms, freely moving about and mixing and commingling with fellow human beings. Right to livelihood in Oliga Tills v. Bombay Municipal Corpo, AIR 1986 SC 185 Judge Bench of Supreme Court has finally ruled that the word life in Article 21 includes the right to livelihood also. The court said, it does not mean merely that life cannot be extinguished or taken away as, for example, by the imposition and execution of death sentence, except according to procedure established by law. That is but one aspect of the right to life. An equally important facet of that right is the right to livelihood, because no person can live without the means of livelihood. If the right to livelihood is not treated as a part of the constitutional right to life, the easiest ways of depriving a person of his right to life would be to deprive him of his means of livelihood. In view of the fact that Articles 30(a) and 41 require the state to secure to the citizen an adequate means of livelihood and the right to work, it would be sheer pedantry to exclude the right to livelihood from the content of the right to life. Similarly, in D.K. Yadav v. JMA Industries, 1993, 3 SCC 258 Supreme Court held that right to life enshrined under Article 21 includes right to livelihood and therefore before terminating the service of an employee or workman fair play requires that a reasonable opportunity should be given to him to explain his case. Right to shelter. In Chameli Singh v. State of UP, 1996, to SCC 549, it has been held that the right to shelter is a fundamental right under Article 21 of the Constitution. In any organized society, the right to live as a human being is not ensured by meeting only the animal needs of man. It is secured only when he is assured of all facilities to benefit himself. Right to live guaranteed in any civilized society implies the right to food, water, decent environment, education, medical care, and shelter. These are basic human rights known to any civilized society. Right to privacy. In our Rajagopal v. State of TN, 1994, 6 SCC 632 popularly known as Auto Shankar case, the Supreme Court has expressly held the right to privacy, or the right to be let alone, is guaranteed by Article 21 of the Constitution. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. None can publish anything concerning the above matters without his consent, whether truthful or otherwise, and whether laudatory or critical. If he does so, he would be violating the right of the person concerned and would be liable to an action for damages. However, possession may be deferred if he voluntarily puts into controversy or voluntarily invites or raises a controversy. This rule is subject to an exception that if any publication of such matters are based on public record, including court record, it will be unobjectionable. Right to health and access to medical treatment. Of late, the right to health and access to medical treatment has been included in the plethora of rights brought under the ambit of Article 21. The attitude of judiciary in expanding the horizons of Article 21 has been analyzed with special reference to the right to health and medical assistance as a right under Article 21. In Vincent Panikurlanga v. Union of India, AIR 1987 SC 990, the Supreme Court held that a healthy body is the very foundation for all human activities. So, in a welfare state, it is the obligation of the state to ensure the creation and the sustaining of conditions congenial to good health. Further, in Parmanand Katara v. Union of India, AIR 1989 SC 2039, a petition was filed under Article 32 of the Constitution, when a private doctor refused to treat a patient who met with an accident because of non-compliance of procedural formalities regarding accident victims. The court ordered the medical institution to provide medical aid and treatment immediately, irrespective of whether the procedural formalities have been complied with. The observation in Parmananda Katara created a new right, the right to get medical aid, and it has become an integral part of Article 21 of the Constitution. This stand has been retreated by the Apex Court in Consumer Education and Research Centre v. Union of India, AIR 1995 SC 922. Right to end one's own life, the issue of attempt to commit suicide brought to life again. In 1994, this offence was declared void by the Division Bench of the Supreme Court P. Rathiram AIR 1994 SC 1844. The court then declared that Section 309 of Indian Penal Code, which provides punishment for an attempt to commit suicide, deserved to be effaced from the statute book to humanize our penal laws. But 2 years thereafter, the full bench of the Apex Court completely overruled the above principle in SMT Gyan Kaur v. State of Punjab case, AIR 1996 SC 1257, by holding that right to life is not like other fundamental rights such as the right to form, association, and speech, which are positive rights. Right to speech includes the right not to speak. The right to form association includes the right not to form association. But right to life does not include the right not to live. Thus, a 5-judge constitutional bench has set off a controversy on the legality of the right to life. Is it compulsory or optional? The court ruled it is compulsory. The state cannot bestow a right to die on the citizens. The state is constitutionally bound to protect a citizen's life, howsoever miserable it may be. In this context, Article 21 of the Constitution is its backbone. Right to education. The Supreme Court of India, by a process of judicial interpretation in Mohini Jain's case, AIR 1992 SC 1858, held that the right to education is a fundamental right under Article 21 of the Constitution, which cannot be denied to a citizen by charging higher fees known as capitation fees. Later on, the correctness of Mohini Jain's case was examined by the full bench of the Apex Court in Unnikrishnan v. State of AP, AIR 1993 SC 2178. The 5-judge bench by 3-2 majority partly agreed with Mohini Jain decision and held that right to education is a fundamental right under Article 21 of the Constitution, as it directly flows from right to life. But as regards its content, the court partly overruled Mohini Jain case and held that the right to free education can be made available only to children until they complete the age of 14 years, but after that the obligation of the state to provide education is subject to the limits of its economic capacity and development. 86th Amendment Act has added a new Article 21- which makes the right of education of children of the age of 6 to 14 years a fundamental right. It also substitutes Article 45, which is as follows: the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. It also added a new fundamental duty to Part 4 of the Constitution. Protection against illegal arrest, detentions, and custodial death in Joginder Kumar v. State of UP, 1994, 4 SCC 260. The Supreme Court has laid down guidelines governing arrest of a person during investigation. This has been done with a view to strike a balance between the needs of police on the one hand and the protection of human rights of citizens from oppression and injustice at the hands of law enforcing agencies. The court has held that a person is not liable to arrest merely on the suspicion of complicity in an offense. There must be some reasonable justification in the opinion of the police officer effecting the arrest that such arrest was necessary and justified. Following are the guidelines laid down by the court. 1. An arrested person being held in custody is entitled, if he so requests, to have one friend, relative or other person who is known to him or likely to have an interest in his welfare told as far as is practicable that he has been arrested and where is being detained. 2. Police officer shall inform the arrested person when he is brought to the police station of this right. 3. An entry shall be required to be made in the diary as to who was informed of the arrest. These protections from power flow from Article 21 and Article 22 of the Constitution, and therefore they must be enforced strictly. Prevention of sexual harassment of working women in a landmark judgment in Vishakhapatnam, State of Rajasthan, AIR 1997 SC 3011. The Supreme Court has laid down exhaustive guidelines to prevent sexual harassment of working women in places of their work until a legislation is enacted for the purpose. The court held that it is the duty of the employer or other responsible person in workplaces or other institutions, whether public or private, to prevent sexual harassment of working women. Ban on smoking in public places in Murli S. Deora v. Union of India. AIR 2002 SC 40. The petitioner filed a public interest litigation in the Supreme Court seeking order for banning smoking in public places. The court, considering the adverse effect of smoking on smokers and other persons, directed central, state governments and union territories to immediately issue orders banning smoking in public places like hospitals, health institutes, public offices, public transport including railways, court buildings, educational institutions, libraries and auditoriums. Fundamental right guaranteed under Article 21 of the Constitution, Inter alia provides that non-smoker shall not be deprived of his life without due process of law. Right to food, starvation, death. State to provide free food. In a significant judgment in Pukal v. Union of India, the Supreme Court has held that the people who are starving because of their inability to purchase food grains have right to get food under Article 21 and therefore they ought to be provided the same free of cost by the states out of surplus stock lying with the states, particularly when it is unused and rotting.